This is a lady, she says she and her ex-husband purchased a car in 2002. They were divorced. He had the car. It was then repossessed in 2003. And now she's having some type of lawyer, I assume a collection lawyer, sending notices to her place of employment. And so the question is, what in the world do I do? Well, first thing is, let's start kind of at the beginning and then we'll work our way forward. So on a typical car loan where you go and buy it from the dealership and the dealership puts down their name as the seller, they put down the terms of the financing, then that typically is going to be a 4-year statute of limitation. But then the question comes up, well, 4 years from when? Well, typically from when you stop paying. And the easy date is usually the date of repossession. And so we start there and then we go 4 years forward, assuming there have been no payments. Then once you get beyond 4 years, then that's typically too long to file suit. So if they took out the loan in 2002, is repossessed 2003, that means we're looking at suit should have been filed in 2007. Now, she's getting these notices to her work. Well, a couple possibilities. One, she was sued before 2007 or even after 2007, and there's a judgment against her. And if there's a judgment against you, then the company that has that judgment has many, many years to collect it. So that'd be the first step is, was there a lawsuit filed? Was there a judgment against us? If there was a judgment, then we need to know, were we served? In other words, did we get the lawsuit papers? Because if we weren't properly served, then we can attack that judgment to knock that out. But if we were served, and even if we had a great statute of limitation defense, but we did not assert it, in other words, we get served with the lawsuit and we just don't do anything, then it's too late to raise that statute of limitation defense. So either we were sued and somebody got a judgment against us, and that's why they're approaching our employer to find out, well, do you work here? How much do you make? And that's to do garnishment, which is usually 25% of our take-home pay. So either we were sued or some company, a collection law firm, whoever it is just reaching out to our employer on a debt they cannot sue us on. And if that's the case, then they're going to have some very serious problems with that. Typically, they cannot reach out to an employer except to simply find out, do we work there? And that's only if they don't already know that. So there's something called location information. That's home address, home phone, place of employment. A debt collector can contact somebody other than us or our spouse to get home address, home phone, place of employment, but nothing else. And typically when they contact an employer, they're saying, what's your position? How long has this person been working here? How much do they make? Who's their supervisor? Way beyond what the law, the Fair Debt Collection Practices Act, allows. So we just need to know, is there a judgment? Is there not a judgment? And why is this collection law firm or somebody pretending to be a collection lawyer contacting your employer? So bottom line is, we got some questions to answer, but quite likely something wrong has happened here. And we should be able to do something about that. So I hope that that's helpful.